To say we must guess and suggest what is probable is a principle we must apply if things are unclear. The accuser has not placed before this court evidence that what happened, what she claims happened. The evidence of the footage does not show, even if you wanted to do on a balance of probabilities, that it happened. It was submitted here that because we can't really know, we must assume that there is a space there where an opportunity of it happening is there.
When the secretary must have gone to the toilet.
Yes. I think it would be a bad precedent, frankly, Chair, to decide in a matter of this nature that we must decide on somebody's guilt and impeachment from their career on a surmise. Well, because there is this time you could have done this horrible thing. It's unfair to everybody to suggest this is gross misconduct claim for which the complainant and her legal representatives want his career to end. And I think if his career must end, it must end because objective facts and evidence are there so that we don't regret later. Nobody must be sexually harassed, but nobody must be falsely accused of sexual harassment by two adults who may have changed their mind post facto. Another misconception that is here is that we must ignore I was stopped by the chair during the cross-examination when I was painstakingly showing the similarities between the initial complaint, so-called initial, and the complaint before us. To reduce it to that it shows that she remembers because she is consistent is truly something that deserves no response. The point we were checking at that is that she had first said she had no access to the initial complaint. And when I took her through not just grammatical errors, spacing, full stop. In fact, I was going to spend the whole day doing it until the chair stopped me because it was so identical.
Were you surprised that I stopped you?
No.
You even showed a misplaced full stop. In the one document was equally misplaced in the other document.
Absolutely. So. Chair, and what it demonstrates to us, and we must be truthful about these things. And if you place to me something that I think my client didn't handle well, I'll tell you. I've already said there are one or two things like I thought I wouldn't do it. I wouldn't say this. But I think it's important for this to realize that first lying or telling a falsehood to a tribunal in a matter of this nature is itself inimical to constitutional values, because so much can happen out of this case. So much. Somebody's case may end. Career may end. And it is equally important that we are fair to the complainant. I'm not asking that she must be ignored and that future complainants must be frightened, but I'm asking that rigor must never be taken out of legal processes because we fear that certain groups will attack us. In fact, the best way to protect this is to demonstrate to both potential harassers and potential complainants that this is a serious matter about which nobody should come unless they know their story. And no respondent, including my client, no respondent must come to be evasive. And I deny the fact that she was evasive. He was embarrassed, but advised properly, and he did it himself, that he will speak the truth about what he did and what he meant. And lastly, the invocation of power dynamics is a range topic that we deal with. And I think I don't deny, no one must deny that power relations are a factor in harassment of any kind, both sexual harassment and harassment in general, in global politics, in personal relations. But to assume that at all times, power relations must dominate how we assess evidence that is before us is itself a dangerous approach to determining cases. There's a big case in this country where a determination is made by describing that the litigant is such an important person. We already have a case like that. Therefore, we will depart from tried principles. And I think it's for that reason that I emphasize that we stick to what is objective, what was put before this tribunal. Because it is only through that that we can reach the other point, whether the conduct was honorable, whether it's conduct unbecoming of a judge, you must first, on what is before you, determine whether the gateway to that honorable, dishonorable honor, which is sexual harassment, has been met. And so in pursuit of these allegations, so much is said about the respondent that he behaved indecently. We've put in enough to show that nothing was shown in this regard. And so we demonstrate that this complaint of sexual harassment is entirely contrived. And this statement must not be misconstrued as undermining what sexual harassment is. My learned friend already said, nobody is saying that relationships in an environment of work should not happen. And I think linked to that is that nobody can suggest that flirting in a particular environment, any environment, is impermissible. What is impermissible is an abuse of power to get what you want by force, creating a hostile environment and doing it in a way that's unwelcome. If you meet that, if you find, Chair and the members of the panel, that these conversations were unwanted by Ms. Mengo, and the evidence shows that they were unwanted.
And the respondent persisted with them.
And the respondent persisted with them. Of course you have to find that, because that's the clear definition of sexual harassment. You know, there's no way of me running away from that legality because I want a client to survive. The fact of the matter is that there are things, if the objective evidence drives you without being selective. You see, the problem that this case is argued, sometimes we must look at the context, the entire conspectus, and when you're there, you are told, yeah, but there may be a no somewhere in between. Don't look at the entire conspectus. The fact of the matter is this: objectively assessed, if this tribunal finds and pulls out clear rebuffs, communication to the respondent that I do not want you to continue with these conversations. If you find conduct of that nature or statements of that nature, you must assess them carefully and rigorously. And of course, if you find that they were unwanted, it will be difficult for you not to find that sexual harassment happened, because you're right within the frame of the definition. It would be dishonest of me as a lawyer to try and wiggle out of that. All I'm saying is that the tenor of these conversations, broadly analyzed in their context and objectively analyzed on the content, on their content, do not demonstrate unwillingness. And if all the things that are quoted, some biblical, the eyes and all of this, if they are interpreted to mean these conversations of people who were melting, who were choosing sexual positions to each other, were not consensual, we're in a dangerous path. We're in a dangerous path about future determination of matters of this nature, which are very serious. And so, as I said, the complainant dedicated several paragraphs to demonstrate that she may have rebuffed, she meant this. When she said hi, she meant this. We submit that nothing in the conversation objectively looked at, you don't have to reinterpret or reconstruct them, demonstrates a rebuff. Nothing whatsoever. And where I say both the experts, in my view, and I think I put this to them, the role of an expert is to truly assist the process. We could have found a witness, a misogynist male who wants to come and defend another man. It wouldn't have worked. We could have found a professor who probably would come here and be disgusted about this complaint. That's not what an expert does. And it's for that reason that we could, as much as we try, to find someone who would assist is difficult. One gets tempted to find someone not to assist the process, but to assist the client. And my suggestion about Docrat, and it's said, I'm not talking about them in their absence, is that we find that their evidence leaned not in favor of the process, but in favor of reconstructing a case. for a litigant, for a complainant. And so
it may be argued that regarding Dockhead,
yes,
to some extent, less so.
Chair, I think so. I think so. I think to be fair to where I fault Dr. Docrat, and I don't think it's, one could say it's lack of intellectual dishonesty or anything, is that it's something any expert can do. I think less so for her because, and I think it's the point that was made, is that when you don't have the entire record, that's the first thing. And two, in your attempt, you give an import to an emoji, for example, because that's, as an expert, what you think, but it's not what the two parties understood it to be. So I think her evidence tended to give an interpretation contrary to what may have been the understanding of the parties conversing. So I think less so for her, but I think the...
But,
yes.
Let me catch you right there.
Please.
But, despite that, at the end of, this was the end of her evidence.
Yes.
He said, however, I will concede that the meaning and understanding of the messages by the parties will be as understood between themselves, not me. Something like that.
She did.
I may be summarizing her inelegantly, but
yes,
in the end, she said, who am I to say they should have understood this message this way and that way, if they, between themselves, understood it in this way? So he really conceded it. Stood aside for a while.
In fact, Chair, to be fair, even Ms. Verton, in the end, she does point out to the weakness of not having seen everything, and she does. I think the both of them, in the end, I think as intellectuals, they both, unlike we lawyers of parties, I think they were able to realize the deficiency of not having the entire record and imposing an interpretation. I think that is where both of them, in the end, I think fairly, looking back at their evidence, were correct. And so, Chair and members of the panel, I will take you to the evidence, but I do not want to repeat it, is that there is a narrow ambit of the inquiry you must make. And in that narrow ambit, the word who initiates is not there. It has particular factors that you must look at. And I say this because there's a loop. You are forced to jump and look at how can a judge do this? It's not nice. It's not your gateway to that analysis. In order for you to find that the respondent did not court properly, don't know what courting properly would be, or acted dishonorably, you must first find that this complaint meets the definition, the fundamental definition of what he was brought here to answer. That's a fair way of looking at it. If you were to ask me that we must have a theological discussion about what I would do as a Catholic or what a Seventh-day Adventist would do or people of a different sect, it's a debate that we can have. But it's unfair to have that debate if you jump over the definition. And if you fall short on the definition, you cannot move to whether the conduct was dishonorable, because that analysis is a jump to subjective questions about which nobody in this room is an expert. And as I said, the Constitution recognizes that judges, like all individuals, enjoy the rights first as human beings. And it's not, when we say freedom of association, we're not trivializing this case. We are saying we are in the realm of two adults courting. And so to impose our subjective judgments is very nice, because we are people, we are judgmental, we ride a moral high horse. It's a nice thing to do. It makes us look better than the rest. But that's not the test. The test is a fundamental definition of what he was brought here to answer. Humiliating him or citing things that didn't happen to invoke emotions in society about what did not happen is itself an unjust approach. And of course, we submit that, and we do this in from paragraph 32, much more, where we say there is no residual misconduct complaint here outside the definition of sexual harassment. Nothing. And it's for that reason that we actually, when one witness who ventured into character evidence came, our witness, she was stopped. Because she was entering a realm, and I accept this, a realm of analyzing subjective things about a person, about Miss Mengo. And I think the tribunal was correct to stop it, but that too must guide us in how we analyze this case. We cannot then venture, if we can't meet the definition of what he was brought here to meet, venture into character. So much was said about him and all of this, or about us being brutal. It doesn't help the case. All I'm saying is that there are objective factors to be determined on this. And so, unsurprisingly, as we say in our heads, the judge president responded to sexual harassment charges only, to that charge. We could have spent time debating other things, and there was no space for that, and there is no, it's unnecessary, it's not relevant, because we're venturing into things that are subjective. The test, as the evidence leader said, we look at, it's objective. We have the evidence. If there was no evidence, you would be permitted to venture into other things of interpreting. But if the accuser is unable, or nobody can place the evidence of what they say happened, it's difficult to charge people with conjecture, not in such a serious matter. Not when we are suggesting something so serious about another human being. And so he was not called upon to meet all of these cases of what is the right way for a judge to court. Can a judge who's judge president court a judge who's not judge president, or someone who's working? It's a different case if we were to meet that, but we're not called upon to meet that. And it's a difficult case discussion to have because it's mingled in subjectivity. And as I said, the act, I don't even want to go to the sexual harassment policy, the recent sexual harassment policy. Because law works that way. There's always an improvement of deficiencies in how we do things. And so to suggest that we must look into a system that is trying to deal with the future in analyzing what happened is I know that while it's being used, we are told no, but yes, it doesn't apply retrospectively. But I think even reference to it is immaterial. It's not helpful. And we deal with the cases of Mutata and Hlopho and Kindred, and we think that reliance is misplaced for this case, quite frankly. And I don't want to bore the tribunal with things. We deal with that from paragraph 47 to paragraph 56. And I wouldn't like to repeat it because I've also dealt with what are the applicable legal principles. And I said when I started chair in the tribunal, there are two cases that are interesting to read about this, because it is reading both of them that will guide taking a fair approach to the complainant and a fair approach to the respondent. It's the case that the McGregor case that I talked about, but I think the Amatole District Municipality case that we've cited this, but I will give members of the panel the proper citation here. Both of them are important. I started with the one that defines the scourge of sexual harassment in society. But the Labour Appeal Court in this one, not that it's unaware of this scourge, deals with a complaint that was deficient. A complaint where no evidence of what is claimed happened is shown. A certain Mr. Fredericks is accused even of something as disgusting as one of the things the respondent is accused of here. Exactly the same. The complainant says, no, he called me to his room, to his office and asked me and showed me his private part or asked me to perform oral sex. And the court finds no such evidence exists. Not that the Labour Appeal Court is unmindful of the seriousness of sexual harassment, but it engages on each case on its own merit. That is one of the most cardinal principles of determining a matter, rather than a broad sweep that assumes that nobody in life lodges a false or a mistaken, erroneous complaint. I said in the beginning that I don't want to attack Ms. Mengo, and I keep using these words because it's possible in error to do something. And that case, the Amatole case, demonstrates better because the judges in that case do go to great lengths to describe even the deficiencies in the evidence of Mr. Fredericks. But assessing objectively the entire evidence, the key areas did not happen. They go as far as saying you can't call a witness reliable when they pointed out things that did not happen. And in that case, they find that the fact that there was reference to things that could not be shown happened. Because if we cannot show that something happened, what are members of any tribunal left with? Conjecture. And if we're going to bring conjecture and assumptions as an important component of legal precedents, it's a terrible precedent. And our courts will be imperiled by an approach of that nature. So